conversation with Mr. Kevin Alvarez, and he has his running, I guess his opponent, Angela Dempsey. But today we just have Mr. Alvarez, so we're going to drill him with all the questions we can think of, and hope you have good answers for them.
I'm ready. I'm ready. Thanks so much for putting it on.
Good, good. That's good news. So before I kind of go into, our part of the segment, I want to give you an opportunity to kind of share with the audience who you are, and what led you to wanting to do this role, and what you believe your responsibilities are if you was to get the role.
So what my experience is, I guess I'll tell you a little bit about myself. I was born in Ocala, Florida. I came up here for undergraduate school and for law school. As soon as I graduated from law school, I went straight into private practice, working with a lady named Annabelle Diaz. Her and I worked together doing mostly criminal defense work for about 5 years. And then I opened my own practice, and I've been doing a mix of criminal defense, very little family, but a little bit there, a lot of civil construction issues. Basically, my role is I get brought in a lot as litigation counsel or as a litigation consultant, because I have a lot of trial experience, especially from doing a lot of criminal defense work. I've had over 50 jury trials. I've represented about 1,000 members of the community, and so I have a lot of experience in that arena. Why I'm running is because of that. I had experience in Judge Dempsey's, my opponent's courtroom, and I didn't think things were being done correctly. I didn't like the large reversal rate that she had of not getting the law correct, and I didn't think it was right. So I know the only way to make a change is to actually put forth some effort and try to make a change. So that's why I put in to run. I know I have plenty of experience to do the job. I know I'll do a great job at it. And I'd ask for your vote on August 18th.
Thank you. Thank you for that elaborate response.
Yes, ma'am.
Now, I do want to ask you a little bit about the transition from being a private attorney and taking on the responsibility of being a judge. I know, especially for judges, you have to have this sense of understanding for character and judgment, a good judgment of character. What experiences do you have in that arena to actually execute the job effectively?
That's a fantastic question. So one of the most important things in my job is gauging credibility, listening to people, making a decision about whether I believe them, whether I don't believe them. Because a lot of times, especially when you're doing criminal defense work, you'll have witnesses, you'll have your clients tell you a story, and you have to try to evaluate real quickly whether that story is true or not, because you can end up hurting your client by going down a road of investigation based on what they've told you that doesn't end up being accurate. So I've spent the past 10 years of my career gauging credibility and trying to determine who's telling me the truth, who's not telling me the truth. And I found one of the most important parts of being successful in that part of the job is to take the time to listen, not just to the words that people are saying, but how they're saying it, to ask good follow-up questions, to sit and listen. And I think that's the most important role of a judge. And one of the things that I took a lot of exception to from my opponent is I think you have to take your time. We've started to transition to this system of mass dockets, of trying to get justice done expediently. And I think that's been at the sacrifice of taking the time it takes to be diligent in each individual case, to sit and listen, to ask the follow-up questions, not only what happened, but why did it happen? How did it happen? How did we get to the point that we're at? And so that's been basically my entire career, is doing that. So I think I'm well prepared for it. The transition is going to be a little difficult because I've been an advocate for the past 10 years. And as a judge, you can't be an advocate for either side. You have to be neutral and you have to listen. I think I'm going to be very, very good at that. That tends to be my personality anyway, is to not get overly emotional and to be able to sit and listen. So I think I can do a good job.
Awesome. So I do want to ask you, well, before I even say what I'm about to say, I need to put out this disclaimer because we have extended the invitation for everyone to come to the forum. So, I mean, we tried to get everyone at least a week in advance. A lot of people rearranged their schedule to be here. So, if anyone is not here and we would have preferred them to be here, please note they did receive an invite from the Florida Community Law Center. With that said, I wanted to ask you, Kevin, because it might be a good thing in your case that Ms. Dempsey isn't here because I know she had a lot to say about your campaign and a lot to say about you. What was your responses? And for those that don't know, I mean, she went on social media, pulling up his old social media sites, and a lot of things that were said on there that she said is not fit. I'm not going to put all your business out, Kevin, so I won't read anything verbatim.
That's okay. That's okay.
But I just want to know what was your response to that situation?
So, it was a little bit of an embarrassing situation, and I don't mind putting myself on blast to a certain extent. I mean, I think everybody is. I think the questions were fair. I don't like the characterization. So, what I did on social media back almost 10 years ago, but when I was well, okay, let's go back to high school. So, because that's about how far back they went and digging through my social media. I had a two-door Mustang. I had subwoofers in the trunk, and I liked rap music. Candidly, I still enjoy rap music. I also like country. I like alternative music. I like a little classical, a little Josh Groban sometimes. And what I did is I quoted some rap lyrics on my social media page. I also talked about some cases and quoted some transcripts and stuff that were kind of vulgar. Granted, I was in my early 20s, and I certainly don't talk with that degree of vulgarity anymore. But that's what I did, and they dug it up, and they've made an allegation that somehow I am racist or sexist because of that. I think vulgar back then would have been fair. An inappropriate sense of humor would have been fair as well. The other comments is political messaging, and that's all they got. And so I understand that they're trying to run their race, and they've decided to take the position that tearing me down is better than trying to defend her own record of judicial reversals for not getting the law right. And that's what they've done. And I think it's fair for people to ask me about it. I'm happy to address it. But that's what I did.
Now, if you ever had to go before her again, do you think it would affect your case, or would you ask her to be recused now that you guys have been through this experience together?
Yeah, generally so. There's some judicial ethics rules that seem to indicate that a judge should be recused for about 2 years after a race is over with to let things cool down. Candidly, I don't think I would ever take especially a criminal case in front of her if I had to do that. Only because I wouldn't want my client to feel like that us going back and forth in this election affected the outcome of their case at all. So I would probably ask her to recuse herself, and if she didn't, I would probably tell the client that it's in their best interest to hire somebody else.
I think that's a fair answer.
Thank you.
Okay, so I have a few questions that I want to ask you about uh, when you do take office. Kind of see foreseeing what your experiences are. Now, please bear with me. I know I'm going to have to slow down and break up some of my sentences because I know that there are a lot of stipulation about what you guys can and cannot answer. So I did vet my questions and I want to make sure I'm in line, but if you can't answer it, we'll respect that. I don't want to jeopardize your race, or if you was to win, jeopardize you ever having to take a case.
Thank you.
Fair enough?
Fair enough. Hit me.
Okay, so in your experience before judges, I know that there is always a large, or excuse me, a big it's a big gap with how people are charged. Can you explain I know that maybe it's a point system. Let's back up. Let's talk about that a little bit. Can you tell me about the point system and how that works in criminal court?
Sure. So in a felony case, sentencing a lot of times is determined by what's called a criminal punishment code score sheet. And what it is the Florida legislature has passed a law that gives every single crime that someone's charged with a certain number of points. And then any additional charges that they have are also worth a certain number of points. And then their prior record is worth a certain number of points. And then if they violated probation and parole is worth a certain number of points. All those points get added up together, and do a little math to it, and it comes out to what the lowest permissible sentence in months that the person can receive if they're convicted at trial or if they enter a plea to the judge. The judge is not allowed to sentence them less than what that number is unless they have what's called a legal basis for a downward departure. Those are also laid out in statute, and some case law has created some other ones. But if the lawyer, the defense attorney, doesn't put on any legal basis to go below the score sheet, then a judge is bound to sentence that individual to the minimum of what they score out to, up to what they could statutorily get as their maximum sentence.
Interesting. Thank you. Well, so can you explain how someone can be charged with resisting arrest, and that would be the only charge that they're held against? Can you explain what allows that to be able to happen?
So resisting arrest can be committed in two ways. You can have resisting arrest with violence or resisting arrest without violence. Resisting with arrest without violence is a misdemeanor offense. Generally, there are some special exceptions that could have somebody held just on that charge pre-trial. But that's rare. Most people are entitled to bond or a pretrial release status or release on unrecognizance for a misdemeanor offense. For felony resisting arrest, that's with offering to do violence. That's also an offense that normally will have a bond set pre-trial. Again, there's subject to some exceptions, like if somebody's on probation, but if that's the only charge that they have, unless they violated their pretrial release conditions in some way, generally those are offenses that somebody can make bond on.
Okay. So I know you talked a lot about, your experiences working with criminal matters. Can you share a little bit with the audience about your experience with civil matters?
Definitely. So I've done a couple of family law cases, simple divorce stuff. I try to stay away from cases with children. As a litigator, I just because my criminal docket generally is very taxing, mixing children's issues in with that. It's just not something I normally do. I also do some construction law stuff. So I advise two companies on different legal compliance issues that they could have. That's anywhere from employment issues, if they're planning on hiring or firing somebody, what are the issues that could result from there? Currently, what we've been doing a lot of is COVID-related stuff, advising them on the payroll protection program that's going on and how to apply for that, how to deal with health compliance, what happens when an employee tests positive for COVID, should they have testing procedures in place? So I've been doing a lot of that type of stuff, and also general business questions that they have. I also do a lot of post-conviction relief stuff, which is considered civil, but it's also kind of part and parcel to criminal, and that's after somebody's been convicted of a crime, going back and reinvestigating the case to see if everything was done properly, and if not, trying to get them some relief.
Okay, thank you for that explanation. So in cases, if you were ever to, you're called to work on cases that involve a civil matter or involve family with children, do you think that you would be experienced enough to properly be able to help them with their cases in a fair way, or?
That's an excellent question. So I think so, because the evidence code is the same generally for all of those different areas of law. And the evidence code is what a judge has to have a commanding knowledge of, so that during a hearing, they can call balls and strikes real quickly. So they can say, this is legally admitted into evidence, this is not legally admitted into evidence. And it's really important to have a commanding knowledge of that. And I do from all my criminal trial experience. The other issues, that's just a matter of when I get the case file, taking the time to sit and diligently research the law, grab a primer, ask questions, read through it, and be prepared. And one of the most important jobs of a judge is to listen to the lawyers about what the law is and to ask the follow-up questions. So if I don't know an answer to a legal issue that's arisen during a hearing, the job of the judge is to take a second and ask the lawyers, hey, and be honest with them. I don't know the answer to this. Can you all get me some case law on this one way or the other? Can you help me figure out what the right direction is to take on this legal matter? And to take the time until I get it right. You know, if it means that we have to take a break and we have to pick up something the next day because I got to do some more research on it, then that's what we're going to do. But we're going to make sure that we get it right and get it right the first time so that somebody's life is not impacted waiting 4, 5, 6, 8, 10 months a year for the appellate court to come back and say, Judge Kevin was wrong.
Fair enough. Yes, I hear you all day. I just wonder. I can imagine we do a lot of memorandums of law here in our office, so I'm like, oh, great, more work.
I can tell you this: if I got to sign,
understand you though, because as long as we get it right, then hey, you just got to do what you got to do. But I just felt that in my chest for a second, like, oh yeah, great.
And I get that, but so I did the family law mediation training already. I went all the way through the certification process. I just didn't observe enough mediations to finish it up. I got busy with criminal court. So I've been through the family law mediation process already. I took family law in law school. I got a pretty good grasp of those issues. So it's only going to be the nuance that I'm going to need a little help with probably at the beginning in some of these different areas. But I'm not scared of doing the work, and my job would be to pull the file beforehand, see what the pleadings are, learn the legal issues before I go in there, and then if it's a nuanced issue, ask the parties for some help on it.
Understood. So I want to kind of go back a little bit, sorry to kind of backpedal, but we were talking about some of the sentencing structures in regards to points, but can you kind of explain a little bit more about the challenges that the courts face with the sentencing gaps, especially for, higher sentencing rates for people of color? So do you know if any efforts are being made, or do you have any plans of doing something about that?
So the issue is a complex one, to say the least. The point system, judges are pretty well bound by, because it's the law that the legislature has passed. So anybody that wants changes to the point system will have to lobby the legislature, and judges aren't allowed to get involved in that process. The other issue is the lawyering. Lawyers have to argue for downward departures when they feel that the evidence is sufficient to warrant it, to even give the judge the authority to go below what the point system is. I think there's two things to address the racial inequities that I think I can do as a judge. The first one is to make sure that I am very careful for any implicit bias that I might have on any issue. That I challenge myself in every single case to think not only what am I thinking, but why am I thinking that? And I think that's really important for every judge and every person in the court system to do, is to not be so arrogant as to think that we know everything. And I think we need to continue to challenge ourselves in that manner. The next thing that I think is really important is judges have to engage. They have to ask questions. I cannot, one of my pet peeves in doing trials as a defense attorney is when we come in for trial and the judge says good morning to the prosecutor, says good morning to the defense attorney, good morning to the bailiff, good morning to the clerk, but not good morning to my client whose name's on the file that they have in their hand. I know it's not intentional, least I hope it's not. But the perception automatically off rip is that this process is not going to be fair because the common pleasantry was not extended. And I think judges have to be really, really diligent to break through that barrier, because what it does is if people think that the system is unfair, then they're unwilling to do the work to present the evidence that a judge would need to make a fair ruling, because then they throw up their hands and say, this isn't going to be fair. Why should I even participate in this process if it's not going to be fair? And I think that's the best thing that a judge can do, is to make sure that everybody that comes to the courtroom is treated with dignity and with respect, and that the judge takes the time to listen. Even if it's a case where the judge isn't going to have a whole lot of discretion, the judge still has to take the time to.
Well, I'm not sure if can you hear me? I'm not sure if we still have the same connection. Oh, you moved. Hey, Kevin, can you hear me?
Hey, I think I can. I think you're back.
Okay, good.
Can you hear me?
Yes, I can. But thank you for your response. I think it got lost in the wind, but wherever it lands, I hope it was a good place. Kevin? Oh, there you go. Kevin. Well, okay, so I did want to also talk to you about youthful offender programs. What are your thoughts on those, and how often are they used, if our judges are still using them? I'd imagine so.
So, two issues with youthful offender. You have youthful offender as a designation that the Department of Corrections uses to place somebody in the youthful offender camp. You also have a statutory basis for downward departure, like we talked about on score sheets, where if somebody scores out to a lot of time or has some specific minimum mandatories, the fact that the person qualifies as youthful offender gives the judge the discretion then to go below. It is my personal belief that judges should have as much discretion as possible to be able to make a fair judgment. And so I am a fan of anything that's going to give judges more sentencing discretion. That being said, I'm going to have to follow the law that the legislature puts into place on those issues. Youthful offender is still around, and I can tell you I have used it dozens of times to help young children who made mistakes not have to suffer a severe penalty because of it. So I'm definitely in favor of anything that gives judges more discretion.
Okay, thank you. And so, for the people, or for the youth that's chosen to go there, if their crime does constitute enough to go to an adult prison, do a judge have an option to say, well, I'm not going to send them to an adult prison, I'm going to send them to a youth camp or a youth program?
So that gets a little complicated. It depends which system we're in. If we're in the adult court system with a young man or woman that meets the age criteria for youthful offender, the judge doesn't get to designate which facility they go to if the judge imposes a youthful offender program incarcerative sentence. The executive branch gets to choose the specific facility that somebody goes to. But the judge gets to make the decision as to whether to give them that designation or not give them that designation. And sometimes I've had clients not want to have the youthful offender designation because of the quality of the program that they go to can sometimes be and I have to be careful how I put this. I had a client back in the day get stabbed, get injured very severely in a youthful offender program, and so I have had some clients say I'd much rather go to an adult facility as opposed to a youthful offender program, but that tends to be program specific. Some are probably fine, but I don't have a whole lot of experience going into them, just from what my clients tell me about them.
So would you be comfortable to say that you would always revert to the youthful offender program? Like every time a child offends and he is arrested, I'm gonna always put them in youthful offender program. Could you do something like that? Could that be something that you make a policy for your office?
So that's one of those questions that I'm not legally allowed to answer. I wouldn't be allowed to legally say what I would do in all cases or in no cases, because I'd need to hear, as a judge, every judge would have to hear the specific facts of each individual case, and then make a determination based on all those facts what's appropriate. And I can say I've done a lot of juvenile work, and children are very, very complicated. And I, as a personal preference, I don't think, and I think the law supports that children should not be written off, really, no matter what they have done. I think that we really need to take our time in these cases involving children to make sure that we get it right, that we not just look at what have they allegedly done, but why did they do that? What was their circumstances that led them to that place? I'm sorry, I'm just not allowed to answer the question of the in every case would I, because I'm going to be bound by whatever the law is at the time.
And that's true. That's, yep. I've heard that before. So I understand your response. So now, if you become a judge, let me ask you, what is your perspective on African American hair and African American culture in the office? Does that make you uncomfortable? Do you think it's distracting, or is that something you welcome?
Oh, that doesn't bother me at all. I actually had a case where I litigated that issue of hairstyle in a Department of Juvenile Justice facility. No, it doesn't make me uncomfortable at all. In fact, I enjoy learning about different cultures and different styles. I think that's cool. I think that's what makes us all individuals, and so that wouldn't bother me at all. In fact, I would stand up for anybody that's getting bullied, shamed, or not permitted to be themselves. I mean, I just think that would be entirely wrong for the judiciary to have or make any policy that would prevent somebody from being themselves.
Kevin, do you think you're impulsive? Would someone ever say that about you?
I think in 2010 and 11, they would definitely say that I was impulsive, and that I was a rabble rouser and I got a couple of speeding tickets there, so I was also driving too fast. Granted, since I turned in the two-door Mustang, I've had two sedans since then. So I would not say that anybody would call me impulsive at this point. Generally, what I get is I'm very tactical. I really take my time to do my research, and I try to hold off on forming any opinion on anything until I have all the facts and have taken the time to argue it from the other side, because that's how you're a good trial attorney, right? You try to envision, what is the other side going to say? How are they going to come at me on this issue?
Okay, and so I missed the last part of your statement. I'm not sure what came up on there, but can you say the last part again?
Sure. Just that I'm very good about thinking about both sides of a case, because with all my trial experience, that's what we have to do, is think about how is the other side going to be coming at us? What are they going to argue, so that then I can prepare to counter that. So
now I wanted to ask you a little bit about you, and if you can kind of share with us what were your experiences, or Did you ever want to be a judge growing up, or is this something that happened during law school or after? When did that come about?
So it came about shortly after I started my certified legal intern program at the public defender's office, where I had, I didn't really want to be a judge before. I really just hadn't given it much thought. But I had a case in a trial where the individual, in my legal opinion, was not guilty. Even if what he had done was true, I still didn't think it constituted a crime. I did all the research, I did the memorandums, argued to the judge till I was blue in the face, and ruled against me. My client was convicted and sent to prison, lost his house, lost his child. And about a year later, the District Court of Appeal said, no, Kevin was right. Even if what the gentleman had done was what he had done, it still wasn't a crime. And I found that so frustrating that I had the law, I gave the judge the law, and the judge didn't follow it. And so I kind of told myself that's got to stop. And so when Judge Dempsey was up, who has a pretty bad reversal record, I said, somebody's got to stand up and run against him, make sure that doesn't happen again. That we have to make sure judges follow the law, whether they like the outcome of them following the law or not. They have to follow it. That's the job. And so that's why I'm running, to make sure that doesn't happen again.
Is there such a thing in the courtroom where it's like work culture for judges? And I mean, it doesn't have to necessarily be in Leon County, but is it such a thing for judges to kind of have, they'll go maybe in their break rooms or in their chambers, and they talk about other attorneys and kind of have their own different ideas of how attorneys are practicing? Is that culture? Is that normal?
I missed the first part of your question. You were cutting in and out just a little bit there.
Oh, sorry. I can repeat it.
If you don't mind.
No. But my question is, in regards to work culture for judges, is it normal for a judge to be talking with other judges about other attorneys and their perspectives of that attorney to other judges? Like, is that a normal thing amongst judges to do?
I don't know for sure because I'm not yet part of that group, but I spent a lot of time around the courthouse. It's a fairly small community. I would not be surprised at all if just by human nature alone, that folks aren't back there talking about what happened in court or who did what or who said what. I would just be shocked if that didn't happen. And I've had experience where judges have come, hey, I heard about that. I think that probably is and does happen back there. And judges are people too, so I would be surprised if they chit chat at the water cooler.
Makes sense. Have you ever heard of the term political prisoner?
So one of my majors was political science. So I've heard political prisoner in the term of somebody being imprisoned in another country by the ruling regime if the person is dared to oppose that ruling regime, generally dictatorships of that nature, authoritarian regimes. So I've heard it in that context.
Okay, so that's a perspective I didn't know about. But the political prisoner that I'm referencing, it's a statement. It was tokened by Angela Davis, and it was basically those who were challenging the law in ways that they just didn't support, and things like protesting, things kind of rebelling a little bit in the community, kind of led them to receive charges like how I mentioned earlier, resisting arrest, or charges like public. I can't even remember exactly the charge, but I think it's public indecency,
disorderly conduct, or that sort of
stuff
stuff
like that. Exactly. And so I was wondering if ever a situation was to come like that before you. I know you can't tell me. Let me kind of back up on my words. Wait a minute. But I guess what I'm asking is just in culture, if is do you see political prisoners these days? Put it like that.
I don't know enough to give you a good answer. I try to be very knowledgeable about the going-ons in America, especially nowadays. I mean, obviously, turn on the news and see protests. Read the paper. I've talked to some of the groups. I've provided some legal advice to other attorneys about different civil rights issues dealing with protesting. I would not be surprised if somebody is. I think it is best way to coin it is your nonviolent protest. It's the example of the police officer telling somebody to move and them saying, I'm not moving. I'm protesting this issue. So they sit down in the street and say, look, you're going to have to arrest me, and they go to jail under a charge based on that for resisting, and that's part of the protest. Especially sometimes you'll see people do that to actually create a case in controversy so that they can litigate the underlying legality of the arrest. Sometimes people cannot challenge something until there's a case that's created. So some people will actually get arrested to create that case so that they can argue that issue.
So would you attend a protest?
Would I or have I?
Both.
So if I'm elected, it would probably be inappropriate for me to attend a protest. Have I? In recent times, no. I filed to run back, oh gosh, it's been a good almost 2 years at this point. And so I'm bound by a lot of those same rules right now, that I'm not allowed to engage in any sort of political process at this point. And so I've been sidelined, so to speak, from any sort of advocacy for the past 2 years outside of the courtroom. I have provided some legal advice to some of the lawyers that had specific criminal law questions, because I have a lot of expertise in that area, but not in recent times.
So then I understand my question. How about, would you, if you could?
So if I was not running for judge, the answer to that is maybe. It depends on the issue. So for example, I wasn't happy with what was going on to a courtroom, in a certain courtroom. So I went down to the supervisor of elections office and filed paperwork to challenge what was going on in the courtroom. So I generally, a lot of the challenges that I've made over the course of my career has been through the legal process, because that's what my skill set is challenging and protesting through that process. If that process was not fair, if that process was not working out, if I was not seeing results in that process, or if I thought that I would be able to make change by doing protesting, of course, I think everybody has an obligation to challenge the government, to challenge people's perceptions, to challenge people's thoughts, and to make sure that the society that we all live in is a society that we all want to live in. And so if that involves protesting, then absolutely that's what needs to take place. And I say that, and I have to put a big disclaimer on there. I cannot talk about current events. So please don't take anything that I've said to be a comment on current events, because it is highly likely that events that are going on in the world today are going to lead to litigation that's going to be before the circuit court in Leon County. So please don't take anything that I've said to prejudge any of those specific issues. We're just talking generally.
Disclaimer noted.
Thank you.
Okay, so we are winding down towards the end. I would like to give you an opportunity to talk to the community and explain to them about the upcoming election. If you can also share what your actual responsibilities are from your perspective, and if you can also just share with them why you think they should vote for you. And you can start now.
Thank you. I appreciate it. So I'm running for circuit court judge, in the Second Judicial Circuit, against the current sitting judge, Angela Dempsey. The day-to-day responsibilities of the judge depend on which specific assignment the chief judge has given them. We have different divisions. It's anything from the criminal division, family division, civil division. And what the job is it's dealing and adjudicating cases and controversies. What that means is two sides don't agree on a legal issue. It could be a defendant, it could be the state attorney. It could be two companies that aren't getting along. It could be a divorce. Somebody has filed a claim with the judge saying, we have this issue, we want you to resolve it. The other side then comes in and says, we have a disagreement on the facts of the law of this issue, Judge. We need you to make a decision. And that's what the job is, to listen to both sides, to be educated on the law, and then to make a fair and just decision, hopefully that both people can live with. And so that's the job. And I think I'd be really good at it because I have a lot of experience doing litigation. And that's what a lot of this circuit judge job stuff is it's litigation. It's being in court, listening to both parties present their arguments, following them, and then making a legal decision. And so because I have almost a decade of experience doing exactly the job of litigating, it's, the best way I can describe it is it's like I'm trying out to be a referee, and I've been playing the game in the major leagues for the past 10 years. And so it's why I asked for your votes, because I have the experience. What I've also done that's a little different from my opponent is I've spent a lot of time working with members of the community in my job, in my practice. I've represented over 1,000 people. And so I have a lot of that personal in-person experience working with people. So I think that makes me far, far better prepared to understand where people are coming from. And so that the decision that I make is a good decision and a right decision. I've done a bunch of appeals as well, and that's challenging whether the judge's decision was right or wrong. So I have a great working knowledge of that process as well. I think I'd be very fair, and I think I do a really good job. And so I'd ask for your vote. And if you have any questions for me, my email address, it's kevinalvarezesq@gmail.com. My phone number is 850-559-0050. I'm available. I'm here. You have questions? Call me. That's the job of a judge is to be available to talk to members of the community. I may not be able to talk about a specific case outside of court because that wouldn't be fair to the other side. But you want to talk generally? Call me. That's what I'm here for. I'm asking for your vote. I need to be available to hear from you. So thank you so much.
Thank you for sharing. And at least I can vouch for that phone call. I think when we called to schedule this forum with you, you answered on maybe the first or second ring. And so thank you for that.
Thank you so much for putting this on too and giving us the opportunity to talk to people.
You're more than welcome. I was very excited to hear that you accepted the invite because I knew we wanted to hear your perspective from, the whole situation with Angela Dempsey. Well, before I let you go, I need to ask you this though. Do you still listen to Jeezy?
I do. I still have Jeezy on my phone. I have all 3 CDs. The Recession was my jam back then and still is sometimes, especially when I need to pep up. And, a lot of it's a commentary on the criminal justice system too. It's what I like.
Awesome. I have to ask you this too. I say this with love. Do you still say the N-word in your rap songs?
I do not, because I have now learned, and not just now, I learned a long time ago that there is such a horrible connotation with that it's not appropriate for me to be saying even if I am singing and rapping a rap song. and certainly not appropriate to post on Facebook. It's just not appropriate. And it's not because I had any sort of hate or maliciousness or any sort of racist tendencies, but it can hurt somebody that I am certainly not intending to hurt or offend. And it's just not, it's not who I am to hurt people or to offend people. And it was stupid.
Let me give you a tweet that has helped a lot of the African American community. It's a simple statement, and it says, everybody ain't able. Got it?
Yes, ma'am. Yes, ma'am. It makes sense to me.
Thanks so much for being here tonight, and I really appreciate all your answers and your time to share with us. And I wish you the best in everything that you endeavor.
Thank you so much. I really appreciate it.
Good night.
Good night.
Awesome. So we just completed the first part of this segment, and it was speaking with Kevin Alvarez, running for Circuit Judge, seat 16. There are 2 seats that are available this upcoming election. There are seat 16 and seat 2. So next we're going to talk with the candidates running for seat 4. What am I talking about? It's seat 4. So we're going to talk with them. But before I go into that, I did want to just thank you all for tuning in and watching and have been staying with us all week and keeping up with all the candidates. I am Rebecca Joseph. I'm with the Florida Community Law Center. We're here for the community. We do want to help educate those who are, now becoming more involved in understanding the importance of being aware of the decisions that are being made in the community where we live. And in the part of that, we want to partner with all of our neighbors and help them in areas of law. So if there's any help that you need in understanding and interpreting the complexity of the law, the Florida Community Law Center is here for you. We're definitely working in areas of guardianship. We can help you in estate planning, writing wills, getting trust. We can help you in all forms of elder law. We can help you in family law cases, in dependency cases, whatever it is that you're going with in the civil realm. More than likely, we can assist you in those areas. So again, thank you all for tuning in. And I want to introduce you to the candidates running for seat 4, Circuit Judge. Tonight we have Miss Amanda Wall, Magistrate Amanda Wall.
Well, I've resigned, so I'm no longer magistrate. Yes.
Oh, that's right. We have to take that down now. And Attorney Tiffany Baker. Hi, Ms. Baker. Uh-oh. Elect Tiffany Baker. Got you. I see the notice. And so is it Miss Wall? Can I call you Amanda Wall? Amanda?
Call me Amanda Wall. Anything you'd like. That's fine. It's no longer magistrate. I had to resign on the date of the qualifications back in April. It's part of the rules of the Supreme Court.
So if after the election, if you aren't able to get the seat, can you go back to magistrate or do you go back to practicing?
Well, I can apply to go back to magistrate, yes. And I am currently doing family law mediations so that I have some sort of income during the time period. So I could always do that as well. So we'll see what happens. I'm hoping to win.
Yes, yes. Now you have experience being a judge when you were magistrate. So what made you say this was the time? Why this election?
Well, I have been, I've wanted to be a judge since I was, back as a prosecutor in Miami. And when I became a magistrate back in 2014, I think I just realized how much it was something that I loved and how gratifying it is to be in court every day and to have the perspective from hearing the cases as opposed to being an advocate and arguing the cases. So I think it just was something that was a natural progression from becoming a magistrate. I realized how much I truly loved and how much I could contribute in the law, which is something that I want to stay in a way that really was fulfilling.
And what were most of the areas you was over, I guess, as magistrate? Do you have like a majority? Was it criminal or What
So
court
as
would
a
you go?
magistrate in our circuit, all around the state, every circuit has a different, sort of assignment for magistrates. And in the Second Circuit, we handle the family law cases. So all of the civil family law matters, not the dependency matters generally. We can hear dependency cases, but we can't do any of the termination of parental rights cases. Magistrate Pedroso here in our circuit does some of the hearings in dependency for Gadsden County. But generally, Judge Shostrom, who's our chief judge, hears or did hear until the change in their assignments just recently, all of the dependency cases. So as a circuit judge, you have a broader jurisdiction. As a magistrate, you have a more narrow jurisdiction. You hear the cases just like a circuit judge does, meaning that you start from the beginning with pre-trial hearings and motions, evidentiary hearings, all the way through to temporary hearings and a final hearing. But you don't have the wide jurisdiction of hearing, for instance, domestic violence cases or as I said, termination cases in dependency or the delinquency cases in family.
Okay, thanks for that explanation. Before we get too far ahead of us, I do want to take the time to introduce Ms. Attorney Tiffany Baker, who also is running for Circuit Judge Seat 4. Ms. Baker, you there?
I am. Sorry for the technical difficulties that I had earlier, but thank you. It is a blessing to be here.
You're here, so that's all that matters.
Amen.
You look perfect. You look like you're in a picture. I didn't know if that was you or your picture up. That was great.
Oh, it's me. It's me. I'm live.
Well, I know that both you and it's so hard not to say Magistrate Wall. I keep tripping up on it. But you and Miss Wall here is running for the same seat. Can you tell me a little bit about your experience in this race and what made you want this particular seat?
Well, my decision to run for circuit judge developed from my practice as a criminal defense attorney. I've learned over the years, after being before several judges, that we have good judges, we have bad judges, and we have the ugly. I decided to run for judge because of the bad and the ugly. I believe that justice is far too precious to turn a blind eye to injustice. So I decided to run for judge in order to serve the community, to give the community a judge that is mindful of rehabilitation as well as incarceration, to give the community a judge who's going to push for implicit bias training for the judges here in the Second Judicial Circuit. Last year in Florida alone, we incarcerated almost 200,000 people. About half of those people were African Americans, yet African Americans make up only 17% of the state population. The numbers for our brown people are just as bleak, and for our growing class of the prison population, which are women. So, those are the two main issues, but also the issue of making sure that everybody is treated with dignity and respect. Practicing before some judges, and I really want to emphasize this, the majority of the judges here in the Second Judicial Circuit are phenomenal. But I have experienced judges who would speak down to my clients, speak down to me, speak down to other attorneys, and I don't believe that creates respect for the bench. And that is why I am running to make sure that we continue to build confidence in the bench. And that's by respecting the people and respecting the law, and that will equal respect for the bench. Thank you.
That's a very powerful answer, I might say. Thanks so much for sharing. So if you can just help me understand what does your role, does it matter in the different seats, or is it just the available seats? What do the seats mean? Is it different responsibilities, different areas? Can anyone explain that?
It just means the availability of It just means the seat, like seat 16 and seat 4, those are the numbers assigned to if they're the same position, circuit judge, but those are just the numbers that are assigned to the seat. So seat 4 is actually becoming available because the Honorable Judge Dotson, who was presiding in cases over in Franklin County, he decided to retire. And so a lot of people know that I was once in Group 16 with Kevin Alvarez and Judge Dempsey. I decided last year in December to switch to seat 4 since I learned that the Honorable Judge Dotson was retiring. And at the time, it was a completely open seat. I was the first person to make that transition. And so that is why I decided to switch from Group 16 to Group 4.
So the seats also, there are 6 counties, as you know, in the Second Circuit. And so the seats also, what happens is we rotate from one position to the next. So although you're in seat 4 when you're elected, you could be for 2 years in Leon County hearing family law cases. And then 2 years later of your 6-year term, you could be rotated down to Franklin County or Jefferson County, or to Gadsden County. You could be the entire 6 years in Leon County in different divisions, because in addition to the 6 counties in Leon County, because it's so large and there's a larger caseload, we have a lot of divisions. So you can be in criminal division, or you could be in civil division, or you could be in family division. And so it's really, there's a lot of places for you to use your expertise in all of those areas of law.
I have a question from the viewers. If someone can answer, or we can do like school. We'll do it traditional. Just raise your hand, and I'll just kind of acknowledge someone. But someone wants to know who's responsible for recusing a judge. Who makes that ultimate decision? Go ahead, Amanda.
Well, when there's a motion for recusal, the judge has to review it for whether it is merited and whether it should be a recusal. But if there are certain issues that are raised, then you grant the recusal and someone else is assigned the case.
Got you. So if the judge doesn't agree with that motion, they basically just have to stay on the case. Is that what you're saying?
I'm sorry?
If the judge does not agree with what the person wrote in their motion,
if there isn't a substantial reason or a legal reason that has been articulated, you mean? Can a recusal be denied? Yes, it could be denied. Mm-hmm. And could it be, like, for instance, in my situation as a magistrate, if I, for some reason, wouldn't have granted a recusal, then they can always try to ask the circuit judge above me, shouldn't this person be recused for this reason? But it's, there are specific legal reasons why you would grant a recusal. And most of the time, if a judge is given, that I've ever seen, if a judge is given a recusal motion for a legal reason, you grant it, because why wouldn't you? If there is a valid reason for recusal, then it should be a recusal.
And for anyone wondering, recusal is just basically when an attorney feels that the judge is maybe biased, or they're just not appropriate to properly handle the case. They can file a motion to ask that this judge be removed and the case be heard by a different judge. Obviously, there's a process to completing that. But the question was, who is ultimately responsible for making that decision, in which Ms. Wall just explained. I did see your hand, Tiffany. Was there something that you wanted to add to Amanda's statement?
Yes, I just wanted to add that it is the judge who is ultimately responsible for making that decision, and the judge would make that decision based on ethical reasons, having the integrity to read the motion and identify why is it that the client or that client's attorney is asking for the judge to remove him or herself. So you would see, for example, a client may say that, well, this judge has certain religious affiliations, or this judge has certain business affiliations. And because of those relationships or because of those affiliations, I don't believe that this judge could unbiasedly or impartially hear my case, because there is something about this judge and their relationship with an issue that is a substantive issue in my case that would prevent that judge from being fair and impartial to me. So that judge has to then review that motion and really check themselves and say, wow, can I be impartial? Can I hear this case impartially? Or is my husband the victim in this case? If my husband is the victim and the defendant is accused of assaulting my husband, I probably shouldn't be the judge on the case. So that's all I wanted to add.
Thanks for clarifying and adding to that. That was all very good and detailed answers. So we really appreciate the information. Now, we do have an activity, it's almost an activity. I would like to call this segment Question, and want to give you, Ms. Wall and Tiffany, an opportunity to ask each other questions. It's going to be for 10 minutes. If that's too long, we can always jump, switch lanes. But I have a feeling that you guys have some good questions for each other. So there is only one condition. I get an opportunity to play. So, and basically all you have to say is question. And when you say question, that means you can ask the question. And then if you're asking a general question and anybody can answer or whatever, we just raise our hand, and then you have the same opportunity as I did. Whoever hand is raised, whoever asked the question, will just say the name of whoever they want to answer.
Okay.
Is that clear?
All right.
We can't compare ourselves. Unfortunately, we can't compare ourselves. You know that, right? For judicial candidates.
No, yeah, of course not.
Just so that's I just want to make it clear, because there are certain things that judicial candidates can't do that regular political candidates can do.
Well, let me tell you this. The part reason why we wanted to allow you guys to ask each other questions, because you guys know what's appropriate and not appropriate to ask. And so to keep you guys protected, I feel like you guys are,
Really? Okay.
You don't think? Okay, so I'm gonna go first because I have a question.
Okay.
And then either of you can follow up with your own questions. But I wanted to ask about your backgrounds with civil and criminal. What are your experiences in both areas? I'd imagine that as judges, these types of cases are going to come before you. So if you can tell the audience what is your background, whoever wants to, go ahead, Amanda, you can go first.
So I have 31 years of experience in the law in the state of Florida, and 6 of those years has been as a magistrate hearing cases and presiding over a courtroom. I started as a criminal prosecutor in Miami. I was hired by Janet Reno right out of law school in 1989, and I worked in Miami at the prosecutor's office down there for 5 years. 4.5 of those years, I was a felony level prosecutor. And for about 1.5 years of that, I was in a specialized unit for felony domestic violence crimes. I also supervised in juvenile crimes while I was in that office. And then from there, I moved to the Attorney General's office, working under Robert Butterworth in Civil Litigation Division. And so in that capacity, I worked as a civil litigator, and those cases were representing the Department of Corrections and the Department of Insurance in tort liability actions that would occur in the prison system. Also in 1983 actions that were the civil rights cases that were brought by inmates. From there, I moved up to Tallahassee 25 years ago, and I have lived here in Tallahassee with my husband. We've raised our kids up here. While I've been in Tallahassee, I've been a civil litigator as well for the Florida Bar, as counsel to the committees for the Florida Bar, all the way from Pensacola over to Jacksonville. And after that, I went into private practice and was a family law litigator for several years. And in 2014 is when I was appointed as the magistrate for for the circuit. So I have a background in all of the areas that will be in the jurisdiction of the circuit court that is this seat for seat 4. Thank you.
Thank you. Now, Tiffany, you're able to answer too. If you want to share, if you can share with the community what your background is in both areas, both civil and criminal.
Thank you. Thank you for unmuting me. So I started out at the Public Defender's Office under Nancy Daniels. And there I handled misdemeanor cases, felony cases. I've done first appearance, evidentiary hearings. I've tried everything from a possession of marijuana all the way up to a quadruple homicide case. I've tried a gambit of criminal trials, and I've never been afraid to actually go to trial. I grew up watching Matlock, and so although I was a finance major in college at the University of Miami and minored in chemistry, I had the opportunity to go work on Wall Street, but I felt my calling was actually in criminal defense. So that is why I chose to come back home. I'm actually born and raised here born in Quincy, Florida, raised there, graduated from Amos P. Gabi here in Tallahassee. So I decided to come back home and serve the people by being, a great criminal defense attorney fighting for justice. After about 1.5 years working at the Public Defender's Office, Jimmy Fasig approached me and he said, "Hey, I hear you're kicking butt and taking names in the courtroom. We are starting to go to trial at my firm, and I would love for you to join us. If you know Jimmy Fasig, you can't say no to Jimmy Fasig." So I decided to join his team, and it was, I had a blast there. I learned so much in handling auto accidents and representing people in slip and falls and defending against summary judgments. It was a great team. I actually got the opportunity to attend a workhorse seminar, for civil litigators to help hone their skills and build their litigation skills. And from there, I left and I started my own sports management firm where, I got the opportunity to represent soccer players from Accra. And that was a great opportunity for me to develop the life experience that, I will use to help transition to being more well-rounded on the bench. Because while there, I got the opportunity to just be exposed to different cultures and different mindsets, which is so important when you're serving as judge, to be able to listen to other people and where they're coming from and to understand them and to listen compassionately. That was a true eye opener for me. But even with my sports management business, I was still practicing criminal defense and in private practice. So I started my own criminal defense firm, and I also practice family law. So I've done divorces, I've done time sharing plans, I've helped individuals regain, the opportunity to be in their child's life. I've handled injunctions for people. I've defended against injunctions. I've successfully obtained injunctions for my clients. So my experience is very well-rounded, and it too covers all 3 areas of what a circuit judge will have to, the majority of what a circuit judge would have to preside over. And that is criminal law, civil litigation, and those family law matters as well. Thank you.
Thank you. Now, I know, Tiffany, you were a second chair to a death penalty case. Can you tell the people how that experience was for you?
That was the most complicated thing that I have ever done in my life. We were in trial for 3 weeks, and throughout those 3 weeks, I averaged 4 hours of sleep. And And, you know, thank God for my husband, because I had an 8-year-old and a 19, well, she wasn't 19 months at the time. I can't remember how old she was, but a small baby who needed nurturing. And her mother was like, no, I have to focus. Anybody who knows me knows that when I have a trial, I am in a special kind of zone. So, but it was one of the most difficult things that I've ever had to experience. But I'm glad that I experienced it, because it allowed for me to, you know, exercise my mind and understand the level of pressure that comes with a death penalty case. I mean, you literally have someone's life at stake, and you're always reminded of that, because those death penalty cases are, the facts in and of themselves are so traumatic. And but you know, what we do as trial attorneys, we press through it and we fight. And Nate and I believe we did a wonderful job. Nathan Prince is an awesome attorney, and I got the opportunity to learn so much from him. And we just learned so much from each other, just combining our different styles of litigation. Was an awesome opportunity to present to the jury and for our client. So I would say that that is how that experience was for me. That would capture that full experience for me. Thank you.
Now, I've asked you a question, so I kind of skipped. You guys can ask a question now.
So I have a question. I have, you know, as a prosecutor, I think I had somewhere around 1,100 or 1,200 trials that I tried or was involved in somehow. And as a family lawyer, I had 6 years of litigation in family law cases. And for the 6 years I've been a magistrate, I've had about 3,000 hearings that I have handled and presided over and written orders for. So my question is, how many cases, because as someone becoming a judge, we all know what our stats are. How many trials have you had, Tiffany?
I would say I've had over 30 trials, with 10 of them being felony trials. And in one way or another, I've been involved with more than that, because when I was a misdemeanor attorney and in the felony division, we had attorneys who would intern from Florida State, who, well, they weren't attorneys then, they were CLIs, they were certified legal interns. And so they would come over to the public defender's office and they would want to get trial experience. And they would need a bar card, an attorney to sit with them while they try their cases. And so sometimes I would sit with those attorneys, but I wouldn't count my experience or my trials as a supervisor to be a trial of mine. So yes, that is my answer. Thank you, Amanda. I have a question.
Shoot.
Okay. Let's see. Are there any gaps in your legal experience? In your professional, and do you have any gaps in your professional experience? I know you've said you've been practicing for 31 years. Did you take any time off?
Yes, in the 31 years, I worked part-time for a period of time because, as I said, my husband and I moved to Tallahassee 25 years ago. We started our family here. We have had 4 children. And during that time, I was lucky enough to work at the Florida bar, where I was able to work part-time. I had a few intermittent periods where I actually was able to take some time off because I had 3 children in 6 years. My first 3 kids were all 2 years apart. So I either had periods where I didn't work for a few months to a few years and then went back part-time. So that was, again, being lucky enough to have the ability to work as counsel to the Florida bar allowed me to work part-time during that period. Then went into private practice. And once I went into private practice, I kind of just geared back up to full-time, even though we had a 4th child. So thank you.
Thank you.
Well, that's good. I mean, you're supposed to multiply, so
Well, yes, and we did. If you knew me when I was in college, you would never think that I would have 4 children, but apparently it worked out well.
well, that many kids in the home, it has to be a happy and entertaining home. So
Very happy.
that's good news.
Yeah. Awesome.
Okay, so I have a question too. So my question can go to anyone, just, kind of raise your hand, but in regards to like death penalties and making those types of decisions, is that something that, and maybe you can tell me by way of experience, I can only imagine it a hard decision to make, but do you have a choice to choose death penalty, or is that a part of the point system where if they qualify for the death penalty, you can't rescind you can't change that option? Go ahead, Tiffany.
So with a death penalty case, the trial is bifurcated. Okay, so you have the guilt phase and the penalty phase. And the same jury that presides over the guilt phase also presides over the penalty phase. So with the guilt phase, the question is whether or not the person is guilty or not. In the Segura trial, it was, of course, everybody knows the verdict came back guilty. And so we had to proceed to proceed to the penalty phase and then put on mitigating evidence. And what normally happens in a death penalty trial is that, you would have an attorney, the defense attorney, to put up evidence as to why they believe their client should not get the death penalty. Whether or not they suffered from some kind of mental illness, whether or not they were abused when they were a child, was it in the heat of passion, something that would explain how a person could do such a horrific, cause such a horrific crime. And then, the state would also get the opportunity to present why, they do believe that the defendant should get the death penalty. And they would talk about, aggravating factors. They would talk about, how the crime was committed. It was done in a heinous and atrocious manner. It was done with a complete disregard for human life. They would present evidence to the jury for them to hear that. And then at the end, the jury would go and they would deliberate just like they would in the guilt phase. And then they would come back with their decision. And even taking everything into consideration, they could say, hey, this person should get the death penalty or not. And then at that point, the judge accepts their decision and then publishes. Yeah.
Oh, I'm sorry. Go ahead, Tiffany. Go ahead.
You're fine. Go ahead.
No, I was just saying, as far as the judges training for that and such, I mean, judges, if that's what the question was about, how judges are involved in that, judges go through special training at Judicial College for death penalty. You have to become death penalty certified. So it really is a very special process that you do. Now, when you become a judge, you are becoming a judge following the law. And in Florida, part of the law is the death penalty. But you do have to go through special certification for that. So I don't know if that goes to your question or not, but
it does. Thank you. And so just so I'm clear, can a circuit judge make that type of decision, or would it have to go up to like county judges?
No, the decision is for the jury.
Gotcha.
The decision is for the jury to make. And that's what I meant by the judge accepts the decision of the jury. The judge can't then take the decision from the jury and say, okay, you guys decided to say he should get the death penalty. I completely disagree with you. No, I am going to set that decision aside. That decision rests with the jury.
Gotcha. And that judge would be one that is death penalty certified to even be able to hear the conversation.
Able to conduct that type of proceeding.
Exactly.
Well, thank y'all for explaining that.
You're welcome.
To ask a question.
I have a question. So, how long you were born in Gadsden County, I know, and how long did you live there, and where else have you lived, and how many years?
Great question. So I left Quincy when I was 13 years old and relocated to Miami, Florida. My mom and my father divorced when I was 13, and that is what prompted the relocation. When I got down there, I realized that I am a true Southern belle, and Miami is not the South. It may be the south of Tallahassee, but it is a completely different culture, completely different city, and altogether. I realized that I preferred to live up here and decided to relocate back up here with my father, who had then moved to Tallahassee. And so that is when I started attending Amos P. Gobby and graduated from Gobby. Following that, I relocated back to Miami and went to college there. And after college, I took 2 years off. So I spent time back here in Tallahassee, traveled from Tallahassee to Atlanta sometimes. But after I decided to go to law school, it was from Tallahassee to Washington, D.C. And then after I got my law school degree in Washington, D.C., came back home to Tallahassee, where I've been ever since. Thank you. Question.
Yes.
What?
Well, it looks like we lost Tiffany for a second. Uh-oh.
I think it froze. I'm not sure.
It does look that way. But while we wait for her to come in, let me ask a quick question. Are judges allowed to create programs? Like, can you guys
create programs? Well, you know, part of therapeutic justice, you know, which is a lot of the courts are therapeutic courts, like Veterans Court and Drug Court and that sort. We have a lot of programs that we have and that we can use and that are already there. Part of the creation of those courts has been because court administration, along with the judges, and the Supreme Court of Florida, quite frankly, have had committees that have gotten together to decide that these are important types of therapeutic courts that need to be there. And so programs can be part of the court system, and judges can volunteer their time to be part of that. They can say they want to be assigned to a therapeutic court. They can say that they want to be assigned to dependency or volunteer for it. As a magistrate, you know, I was able to volunteer to be on Supreme Court committees. I was appointed by the Chief Justice of the Supreme Court to the Standing Committee for the state of Florida on children and families in the courts. And that committee, for instance, is the committee that talks about and reviews the types of specialty courts that we have for domestic violence, for instance. And there are mental health courts that are part of the Florida Supreme Court committees, where they're reviewed, and the types of programs that should be that are the best programs out there that the committees have been able to investigate are instituted. A lot of the programs that occur in the justice system, whether it's for civil cases or criminal cases, come through the legislature, of course. And the committees that you can be on as a judge or as a magistrate, like I have been, are committees that are given, you know, their opinions, and legislators will come before the committees to explain how the process works, because we're not the ones that make the law, but we can give, you know, how the administration of this law would affect the court system. We can give that kind of advice. So there's a lot of ability to participate as a judge, as a magistrate in the system to help bring good programs and good courts into existence. And that does happen, and it happens now.
Gotcha. Tiffany, you're back. I'll let you ask your question, because I have a follow-up question, and then I kind of want to give you guys a chance to address the community directly as to why they should vote for you. So go ahead, Tiffany.
My question is, Magistrate Wall, Ms. Wall, will you feel the need to recuse yourself if you have a 1983 claim brought before you?
1983 claim?
Yes. No, I'm sorry.
I can't, I don't know what the facts of any case would be. So I can't say point blank that I would or would not recuse, but I don't know any particular reason why I would need to recuse myself in a 1983 action.
Okay.
Unless
All
there
right.
was a particular fact that was, you know, that was brought before me, of course.
Tiffany,
Okay.
did you want to elaborate a little bit on the 1983 case?
Well,
What that actually is?
well, Ms. Wall, you said that you represented
The Department of Corrections.
Department of Corrections, right? Against claims that were brought by those defendants in the Department of Corrections, and they would file 1983 civil rights claims, right?
That's correct, right? That's
Right.
something that happens. That is a very large portion of the responsibilities of attorneys general, assistant attorney generals who are in the civil litigation division. That's a
Right.
large portion of the cases, yes.
Right. So my question, I guess, to be more pointed, then you have probably represented Horizon and other agencies within the Department of Corrections, because I know my mother, as a mental health counselor, she retired over 25 years working with the Florida Department of Corrections. And one of the mental health facilities within the Department of Corrections is Horizon. And I know from personal experience, you know, that there are a lot of claims against those medical agencies within the prison system. So I didn't know if you were closely affiliated with those agencies by, you know, your relationship of defending them, because I know if I have to, and just let me finish, if I have to, if a client comes to me and I and they want my representation, but they were in an altercation with someone I've already represented, then I have to recuse myself as an attorney. I mean, not recuse myself, I can't represent that person because there's a conflict of interest. So I was wondering if you would also see that being to be a conflict of interest if you were to get a 1983 claim against someone that you have, against an agency that you've represented before in the past.
Well, I represented the Department of Corrections and the Department of Insurance between 1994 and 1996. And Horizon, was it Horizon? Is that the name that you're using? Yeah.
It's
that
Horizon with the C.
I'm sorry, say it again.
It's Horizon with the C.
Right. I don't have any recollection of ever having a case that involved them in 1994 to 96. However, as I said, if I ever had someone come before me with a motion to recuse, if there's a valid reason for it, of course, a recusal is granted. But as I said, I don't believe that that was the case during that period of time that I ever had any cases with them.
Okay.
Thank you. Thanks for the question.
No problem.
That was very interesting. Now, so that actually leads to my question. I'm going to ask it to both of you. I'm going to ask you, Ms. Baker, and then I'm going to have Ms. Waugh answer last. But the question is, how comfortable are you guys dealing with cases that you will receive that you don't share that same background to it? So if, you know, you don't really understand that lifestyle, or I don't want to say you don't understand it, but if it doesn't seem apparent to, how comfortable would you be hearing cases like that?
Wait, what's the question again? Can you repeat that?
I can. Let me reword it, actually. Try and reword it. So everyone, you know, you have your way of lifestyle growing up, and you're used to, you know, experiencing life as you know it. So what tactics do you guys have to deal with cases where you have to hear cases of families and situations before you where their lifestyles is not something that you personally have ever lived?
Right. So that's a great question, because that gets into how I distinguish being a judge and being a good judge. So, you know, as you've already heard, Attorney Wall and I, there's a vast difference in our experience. She has 31 years experience. I have 7 years of experience. The JNC or the JQC, they say, look, you need 5 years of legal experience. You need to be in good standing with the law. You need to live within the circuit that you're applying for, and you can qualify to become judge. So, you know, if you have the requisite legal experience, you can qualify to become judge. But experience does not equal fairness. Experience does not equal impartial. Experience does not equal treating everyone with dignity and respect. Because there have been experienced judges that have motivated me to run for judge in order to build confidence in the bench by respecting the people, respecting the law, and respecting the bench. So I believe it is my life experience that will make me a good judge, because my life experience has been basically a course on diversity. Like I brought up earlier, I come from a small, quaint, beautiful town of Quincy, Florida, where, you know, we went to church every Wednesday, every Sunday. We borrowed sugar and eggs from our neighbors. And, you know, we were a close-knit family and community. Left there, went to Miami, completely different. Was exposed to different cultures where people thought because of my curly hair, I was Dominican or Jamaican. And I'm like, okay, I'm just Black. And so, but from there came to Tallahassee, you know, which is, even though it's 20 miles from Quincy, it's still different. It's bigger. There are more opportunities here. There are, you know, there's just a different culture here in Tallahassee than there is in Quincy. And then from there, you know, I spent summers with my sister in Los Angeles, and then going up to DC, which is a huge melting pot of cultures and mindsets and different ways of thinking. And then, you know, I spent time in Ghana, and before I even started my business, I clerked in Ghana, in Accra, Ghana, for Justice Rose Owusu, and for a summer. And so just being over there and being exposed to different cultures and you know, religions and mindsets, and getting the opportunity to really, you know what drives people and how they look at family, how they look at life. It really taught me that, you know, respect is fundamental, and it is the cornerstone of order. And always be open-minded, because the way you may think about a situation could be completely different from the way another person thinks about the situation. But the way you reach understanding is through compassionate listening. And when a person listens, when a person listens, it opens up the opportunity for understanding. And that understanding is the connection. And that is so important as judge, because as judge, it is your role, it is your duty to make sure you get to justice. And if you don't understand where, you can't meet that person where they are, you can't find the facts and understand, you know, what the issue is, then you won't ever get to justice. So listening and listening compassionately, I believe, is the gateway to justice. You can't get to justice if you're not listening. So I hope that has answered your question, and I thank you for it.
It was elaborate. So thank you for your answer. I also would like to, we are out of time, but I still want to give you guys, or you, Amanda, an opportunity to answer and still give you a chance for your final remarks. So what you kind of did it, I think, Tiffany, but that's okay. If you have more in the chamber, we want to give you a chance to say it.
Well, I think a good judge is a judge that is impartial and fair and unbiased in the case and prepared for the case. Experience now, I think, is something that is more important, more than ever, not just because of the COVID-19 crisis, which has really affected our court system in an incredibly important way. Cases are backed up in criminal law cases. There have been no jury trials happening for the past 6 months, almost 6 months. We don't know when they're going to begin. Is it going to be the end of the year or prior to that? Having the ability to understand how to run a courtroom is very different than being an advocate. I was an advocate for 25 years as a litigator. And there's nothing that I'm saying that's negative about that. Obviously, it's a very important part of becoming a judge, because you understand how to try a case, how important it is to know evidence and procedure. That's what a judge does every day, is make decisions on evidence and procedure. But in the 6 years that I've been able to run a courtroom, I have been able to understand and learn so much about what it is. It's a good training ground as a magistrate, what it is to become a judge. Having the ability to go to judicial college. I didn't just go to judicial college twice. I've taught judicial college as a faculty member for ethics and procedure. And I've had the diversity training, not just from judicial college, which is an incredibly great program and curriculum that they have for learning about bias and learning about implicit bias, but also in our own circuit, we have, 2 judges who are prominent in teaching about bias and about diversity. Judge Akins, and I've gone through his and gotten my certification through his course that he has for the court system for all of the judges and magistrates in our own circuit, and through Nina Ashanafi Richardson, who also teaches at the Judicial College ethics and teaches diversity and about bias and implicit bias. So yeah, these are really important issues that you educate yourself on, and that you don't just educate yourself on, but that you become aware of and that you put into practice. And I feel confident that if you ask anyone in the courthouse, clerks to other officers, to administrative staff, to support staff, that I have a reputation for being unbiased and prepared and impartial for my cases. And that's in 6 years of cases, over 3,000 cases. So I feel that I have the ability to handle these issues that we have now before the court that are so important, and to steer our courts along with the other judges into 2021 to deal with all of these issues that are going to be continuing. So that we can be successful again in giving access to courts and giving people the ability to be before the court. So thank you.
Thank you. So we're going to now do our final remarks. I don't know, it sounded like you kind of got some of that in there, Amanda, but you can go again if you'd like to, but
a little bit.
Tiffany, did you want to go first?
Sure. Are we ready? Okay.
Yes, ma'am.
This time that we're living in, we're living in a society during a time where our relationship with law enforcement is strenuous, and society is working to strengthen its relationship with law enforcement. And we can't have the issues that, the issues with the blue bleed over to the black. The judiciary must remain a beacon of justice. And so I believe I'm running because I believe that in order to build confidence in the judiciary must respect the people and respect the law. Now, I've been in front of experienced judges who have failed to follow the law. I have been in front of experienced judges who were not fair, who were biased and very partial. And even more troubling, did not show the people who stood before them with dignity and respect. We are in a time, not because of just COVID, we are living in a time where people are really starting to take notice of the criminal justice reform that is sweeping this nation, and the importance of making sure that we put emphasis on rehabilitation along with the incarceration. People are waking up to the fact that if we don't put more focus on rehabilitation, then it is going to break our financial system. It is breaking our communities. It is breaking our households. So how can we fix it? Experience alone will not fix it. We have to put judges on the bench with the right mindset to address the issues and meet people where they are. That is why it was important for me to get out in the community and start campaigning more than a year ago. I got out on the ground and talked to people about what is it do they want from their judge. Not one person said experience, but I can tell you over and over and over again, we heard, we want to be treated with respect. I want to feel confident that when I step in the courtroom, I'm not being judged by the color of my skin. That when I get a sentence, it is a fair sentence. I'm not getting a sentence because I'm this color and another person is getting a sentence because they're that color. Or I come from this zip code and another person is coming from another zip code getting a different sentence. Or because I have a public defender, but this person got a different sentence and they have a private attorney. People want a judge who is going to listen to them and be fair. And if that's the case, I have over 35 years of that. And what's important in this race is that we also have judges who are going to follow the law. Our country, like I said, the issues with the blue should not bleed over onto the black road. And we have to have judges who are not going to play politics and make rulings because it would offend their political connects. No, we have to have judges who are willing, who have the courage to put their personal beliefs, their parties aside and say, what is best for justice? Right is right and wrong is wrong. And we have to have judges who are going to follow the law. That is how you respect it. So I am running because I believe in respecting the people, respecting the law, and respecting the bench. And so I ask, if you believe in those same things, vote for Tiffany Baker come August the 18th. Thank you.
Well said, Ms. Baker. Thank you.
Thank you.
So Rebecca, Tiffany, I absolutely agree that it is dignity and respect for the court system, dignity and respect for everyone who comes before the court, whether it is an attorney, a litigant, a witness, whomever, the family members who are there, who are present. The court system should be something that is revered by everyone in the community. And I have a passion for that. And I have in all of the years of the 31 years of legal experience, but in the 6 years in the courtroom and running a courtroom. And I can also add to that, in addition to that type of respect and that type of reverence for the system, having the experience, but also having the passion to learn more and to do more. And in that, for instance, I've become trauma certified as a professional, as a judicial professional, while I was a magistrate through Florida State University's social work department. Why? Because it is an extremely important part of the fact that I was hearing and presiding over family law cases. You know, trauma in the court system, starting with the understanding of how it affects children from dependency court, going through to family court, going through to delinquency court, and the trajectory that so many children take toward that, and having to go and end up in the criminal system because there isn't an awareness and there isn't an understanding of how trauma affects children and families. You know, the family law area that I've really been involved in for the past 13 years of my life is 40% of what comes in the courthouse every day. 60% is the rest of the civil law that we're talking about here tonight and the criminal law. But the family law, which is delinquency, dependency, domestic violence, and civil family, is 40% of what comes in the courthouse every day. And having a passion and an understanding of why people end up where they are and what is available to help those families is extremely important. And so I agree 100% with what you've said. And I hope that you will vote for me. I hope you will vote for the fact that I have dedicated my career to public service as well as in all of the different areas of criminal, civil, and family law, and really devoted a large portion of my career to children and families in the courts. And I hope that you will find that to be an important aspect in your voting. Please vote on August 18th, and early voting begins actually August the 3rd. So thank you all tonight. Thank you so much.
Well, thank you again for joining us this evening, ladies. We really appreciate your time. You all have really made some really clear and awesome remarks. Yours was also well said, Amanda. Also, we do wish you both the best and well wishes to you. Hope that you get the outcome that you're hoping, and if not, that even afterwards it leads to something even better.
Thank you so much, Rebecca. Thank you, Tiffany.
Thank you, Amanda. You take care, and thank you, Rebecca. This is great.
You're welcome.
Thank you.
Good to see the both of you. Have a good night.
So this concludes our Thursday night discussion with the circuit judges. We had the opportunity to speak with the candidate from seat 16, Kevin Alvarez, and then we ended it with seat 4, where we were able to speak with Amanda Wall and Tiffany Baker. So we are happy that you all took the time to join us this evening, and I hope that you feel really informed and educated about this question of what will appear on our ballot on August 18th. So if you have any questions and any support in regards to voting or in regards to legal matters, or community action will always be here for you. So give us a call or visit our website for more information. If you're not already following us on Instagram or liking us on Facebook, please do so. We can be found at SL Community Law Center, at SL Community Law Center, or you can subscribe to our YouTube, which is at
SL Community Law Center, for more information and for more learning opportunities to learn about our local economy. Thank you so much for tuning in tonight, and I hope you have a great evening. Bye-bye.